wounds. NewsX has now exclusively accessed the 142-page judgment in the 2020 Delhi Riots case. Remember, in a major ruling today, the Supreme Court rejected bail pleas of activists Umar Khalid and Sharjeel Imam in the UAPA case related to the alleged larger conspiracy behind the 2020 Northeast Delhi riots. The court, however, granted conditional bail to 5 other co-accused. The riots, which erupted amid protests against the Citizenship Act, had claimed 53 lives and left hundreds injured. I have Siddharth Rege joining me on the phone line. Siddharth, over to you.
Yes, Vaishali, we've accessed this 142-page charge sheet in the judgment that has been given by the Supreme Court today, and I'm quickly going to take you through everything that the Supreme Court has said. But first, for some background, this is a brief background that has been attached as a part of the judgment. It says it is alleged that as a part of the said conspiracy, Umar Khalid delivered provocative speeches calling upon people to come out on the streets and block roads during the visit of the then President of the United States of America, Mr. Donald Trump, on 24th and 25th February 2020. We've exclusively accessed this charge sheet. The alleged objective of such actions was to internationalize the narrative that minorities in India were being ill-treated and tortured. It is further alleged that women and children were deliberately mobilized to come out on the streets in various localities of Delhi to escalate tensions and precipitate communal violence. The FIR further reveals, it's also mentioned these places where the violence took place. So these were the seven accused in this particular case. 5 of them have now been given a bail. Gulfisha Fatima given a bail. Sharjeel Imam obviously continues to remain in jail. Miran Haider, who has been given the bail. Umar Khalid, who continues to be in the jail. Shifa Rahman, who is on bail. Mohammad Salim Khan, who's on bail. Shadab Ahmed, who's been given the bail as well. Further, this is the charge sheet that the Delhi police has submitted in the court, on the basis of which the Supreme Court obviously has formed its judgment. I'm going to read out excerpts from this charge sheet as well. And this obviously is a crucial part, because this is what Umar Khalid is being alleged of, and this is why the prosecution under the UAPA has begun. So the court in this particular says that that Article 21 has never been understood as operating in the isolation from law. The constitutional promise is not that liberty will be unregulated, but that deprivations of liberty will not be arbitrary, unconscionable, or unfair. The expression procedure established by law reflects that balance. The UAP has a special statute enacted to address offences alleged to affect the security of the state and stability of civic life, represents a legislative judgment as to conditions under which bail may be granted or pre-trial. So the court clearly defining Article 21 in this particular judgment as well.
I also have Sambhav Sharma joining me on this story. Sambhav, what more can you tell us?
Well, absolutely, 142 pages judgment of the top court, Supreme Court in the Delhi Riots case. 142 pages detailed judgment penned by 2 judges of the Supreme Court, finally signed by Justice Arvind Kumar and Justice N.V. Ancharya. I have the copy of the judgment, and 444 points in this particular judgment by the Supreme Court 2-judge bench, where the bail on one hand was granted to 5 accused in this particular case, and bail is being denied to 2 accused, Sharjeel Imam and Umar Khalid, by the Supreme Court today. If I can break it down further to our viewers, on page number 3031, the Supreme Court has said that no collective approach in bail matters under UAPA. The Supreme Court has held that the bail can be decided on accused specific cases, on accused specific basis, individual basis, and court must avoid a collective and unified approach, a detailed judgment. Everything is in a way discussed out in this judgment, both the prosecution angle, what the prosecution has said, what the Delhi police has said in detail has been written in the judgment, and also on the other hand, what the accused lawyers have said in this particular judgment. Another very important point, Article 21 of Indian Constitution, which is in a way core, which is also part of the basic structure of which is a basic structure of Indian Constitution. Here, the
All right,
Supreme Court
Sambhav,
has
stay
said that
on with
Article
me. As per pages 30, 31 of Section 5, individualized role and differentiation, of course,
Vaishali,
is now the differentiation. The Supreme Court held that bail must be decided on an accused specific basis and courts must avoid a collective or unified approach. Siddharth Rege is back with me. Siddharth, what more can you tell us?
Vaishali, absolutely. We have these pages that we've mentioned, page number 30 and 31 of the judgment open right here. And this is where the Supreme Court really details the most operative part of the judgment as to why 5 of these accused have been granted a bail and Umar Khalid and Sharjeel Imam remain being in the jail, are going to be remaining in jail. So, number 5 of the judgment, point number 5 of the judgment says, individualized role and differentiation in treatment of the prime conspirators with others. Before we proceed to individually analyze each of the role attributed to each of the accused, we would like to reiterate the obvious but very important distinction while considering the bail applications in general and under special statutes like UAPA. The record discloses that all the appellants do not stand on an equal footing as regards culpability. The allegations against the principal accused indicate a central and directive role in conceptualizing, planning and coordinating the alleged terrorist act, whereas the material against certain co-accused reflects conduct of a subsidiary or a facilitative nature. The hierarchy of participation emerging from the prosecution's case itself requires the court to assess each application individually rather than proceed on the premise of equivalence. Such differentiation is intrinsic to criminal adjudication and operates irrespective of the uniformity of the charges framed. In the case of alleged masterminds, Sharjeel Imam and Umar Khalid, very important, Vaishali, the prosecution material comprises direct, corroborative and contemporaneous evidence including recoveries, digital communication trails and statements indicative of managerial responsibility. In contrast, involvement of others is sought to be established mainly through associative or peripheral conduct. The court cannot ignore that where evidentiary strength varies materially between accused persons, the need for continued detention likewise varies. Detention that remains necessary to secure ongoing prosecutorial objectives for the principal offenders may not retain the same necessity for those of limited attribution. The alleged masterminds are stated to have exercised command authority and to possess the ability to mobilize or influence individuals within and outside their immediate circles. Such allegations, when supported by preliminary material, compel heightened caution regarding the possibility of interference with witnesses or reactivation of dormant networks. As against this, co-accused with no independent capacity to mobilize resources or exert organizational leverage do not present the same systemic risk. The logic of detention cannot be applied homogeneously where the risk profiles of the accused are markedly dissimilar. So you see the court clearly drawing a distinction between the role of Umar Khalid and Sharjeel Imam, who are the co-conspirators, have clearly been mentioned as the co-conspirators and the alleged masterminds. I'd like to highlight that word there that the court is using as opposed to the other 5 who've been called facilitators in this particular case.
We also have Sambhav Sharma joining us with more details. Sambhav, what more can you add to all this information that we're getting?
Well, absolutely. Here, Siddharth is breaking down the judgment copy of the Supreme Court. Important points highlighted by the top court. I want to add on few more, which the Supreme Court has said in the morning as well, defining in a way, the UAPA charges and especially the terrorist act. What is this terrorist act? The meaning of terrorist act under UAPA is broad, is what is said by this 2-judge bench of the Supreme Court. The court has clarified that the terrorist act is not limited to the use of weapons and may include acts intended to disrupt civic life or threaten national security. This is what was highlighted by the Supreme Court this morning as well, and likewise, Supreme Court is mentioned on page number 24 to 26 to 28 of its detailed judgment. 444 points in the detailed judgment, 42 pages judgment of the Supreme Court, and Supreme Court has clarified a lot of things in this particular judgment. On also conspiracy liability under UAPA extends beyond physical violence, is what is said by Supreme Court. Planning, coordination, mobilization, facilitation can attract UAPA provisions even without direct participation in violence. This is another very important point of the judgment. And also, Omar Khalid and Sharjil Imam are placed on different footing by the Supreme Court, by the top court of the country. The court found prima facie material indicating, in a way, directive role attributed to them in the alleged conspiracy. Remember, the matter is already going on in the lower court in Delhi, in the Karkatuma court, and now the Supreme Court is, now here the top court of the country, Supreme Court, is coming up with this detailed judgment in this particular case, where on one hand, bail has been granted to five accused in this 2020 Northeast Delhi Riots case, and on the other hand, 2 accused has not been granted bail. They were denied bail, and details of why the bail has been denied is given by the Supreme Court in its judgment copy. And the Supreme Court has granted bail to 5 accused. Another important point is that bail stage is not meant for testing defense or conducting a mini trial. Court must not weigh evidence or examine defenses in detail at the bail stage, is what is said by Supreme Court. And also, very important aspect here is the bench clarified.
Right, Sambhav, stay on with me. Siddharth Ray is back and he'll add some more to this. Yes, over to you, Siddharth.
So this is a very important part of the judgment. It focuses on the discussion that happened on the role and findings as far as this charge sheet is concerned. So on 4th December 2019, immediately after the Cabinet Committee accorded the approval to Citizenship Amendment Bill 2019, a WhatsApp group by the name Muslim Students of JNU was created. The charge sheet discloses that the formation of the said group was the brainchild of accused Sharjil Imam. It is further alleged that in his chats with Arshad Warsi, a student of Jamia Millia Islamia University, Sharjil Imam indicated that he was in contact with a radical communal group known as Students of Jamia. According to the charge sheet, the said group was engaged in distributing pamphlets in various mosques in Delhi against the verdict of this court in the Babri Masjid matter, which pamphlets were allegedly aimed at mobilizing students of Jamia Millia University to participate in a protest proposed to be held on 6th December 2019 at 4:30 p.m. The charge sheet further reveals that on 6th December 2019, pamphlets were distributed in the areas of Jama Masjid and Nizamuddin by Sharjil Imam, along with members of SOJ, which, according to the prosecution, allegedly contained content capable of creating fear and insecurity among the Muslim community. The pamphlets were also carried a call to join a protest organized by United Against Hate on 7 December at Jantar Mantar. Chats exchanged between Sharjil Imam and Arshad Warsi allegedly indicate Sharjil Imam's intention to participate in the Jantar Mantar protest and his plan to mobilize students from Aligarh Muslim University and Delhi University with the assistance of MSJ. The chats of the core members of MSJ further reveal that on 8th December 2019, Sharjil Imam was invited to a meeting organized by Yogendra Yadav at the basement of a premises bearing number 66 Janpura Extension, Delhi. The said meeting was allegedly convened with the objective of conspiring to incite a chakka jam, and Umar Khalid is stated to have attended the said meeting. The charge sheet further states that on 10th December 2019, upon CAB being passed by the Lok Sabha and becoming law, members of MSJ burnt a copy of CAA within the JNU campus. Another WhatsApp group titled CAB team was formed on 8 December 2019, and chats exchanged therein allegedly disclose a conspiracy to organize protests on 10th December 2019 at Jantar Mantar against the CAA. The said protest allegedly drew significant attention and was attended by several students, including Umar Khalid. On 10th December 2019, Nadeem Khan, one of the top conspirators and a close associate of Umar Khalid, who is also a mentor of Sharjeel Imam, directed Sharjeel Imam to visit Aligarh Muslim University to mobilize the students for protest. On 10th December, Nadeem Khan, stated to be a close associate of Umar Khalid, as mentioned earlier, and a mentor to Sharjeel Imam, allegedly directed Sharjeel Imam to visit AMU for mobilizing students for the protest. On 11th December, Sharjeel Imam allegedly reached Aligarh. On 12th December, Asif Iqbal Tanha, an accused in the case and prominent member of the Student Islamic Organization of India, issued a call for a protest march to Parliament from JMI against the CAA. Pursuant thereto, a new WhatsApp group titled Muslim Students of JNU 1 was created at behest of Sharjeel Imam. It is alleged that on 13th December 2019, members of MSJ were directed by Sharjeel Imam to reach Jamia Millia Islamia University, following which protests took place at the said campus. CDR analysis is stated to reveal Sharjeel Imam's presence in Jamia Millia University on the said date. They have also detailed the dialogues or rather the speeches that were given by Sharjeel Imam in these mobilization meetings held at JNU, Jamia, AMU, and all these associated groups in these universities, Vaishali.
I have Sambhav Sharma back with me. Sambhav, what can you add to this?
Well, here Siddharth is already putting out what is argued in the Supreme Court by Additional Solicitor General S.V. Raju and also by other senior advocates in the Supreme Court, both from the side of prosecution, but the prosecution has said, what the Delhi police has said, and Delhi police's lawyers said in the Supreme Court, and also what the other side, the accused lawyers, have said in the Supreme Court, and how this alleged conspiracy was hatched, planned, in a proper way as per the Delhi police. So these were those arguments made in the Supreme Court. But here the Supreme Court has took everything on record, especially the arguments made by Additional Solicitor General S.V. Raju, including pointer number 123, 124, where as per pointer number 124, which is on page number 38 of this particular judgment, here learned ASD S.V. Raju submitted that the prosecution relies upon the contemporaneous electronic devices, basically the electronic devices, including the WhatsApp chats recovered from the applicant devices, which demonstrate the applicant created and administered the WhatsApp group. And the name of that WhatsApp group, as per ASD S.V. Raju, was Muslim Students of JNU. This group, as recorded by the High Court, functioned as a coordinating mechanism for mobilizing, identification of the protest sites, dissemination of the protest strategy, and synchronization of the Chakka Jam across locations. And also the appellant's leadership role in this group is corroborated by witness statements and digital footprints. So basically, these all were the evidences put forth by the Delhi police in the Supreme Court, earlier in the Delhi High Court, and why they are important to discuss out, this particular pointer, what the ASD has said in the Supreme Court, is because Supreme Court has denied bail to these two accused, Sharjeel Imam and Omar Khalid, and also the Supreme Court in its judgment is saying that everybody, no collective approach. Collective approach in bail matters under UAPA, that cannot be done. The Supreme Court has held that a bail must be decided on accused specific case basis. And these were the important arguments made by Additional Solicitor General and other senior advocates in the Supreme Court in this particular Northeast Delhi riots hearing in the top court. And the Supreme Court later on, today, has rejected the bail petition of two accused, Omar Khalid and Sharjeel Imam. The Supreme Court has made it clear in its judgment, in 142 pages judgment, 444 pointers judgment, the two-judge judgment of the Supreme Court. The Supreme Court has held that the bail must be decided on accused specific basis, and court must avoid a collective and unified approach. So in a way, it's a direction to the courts of the country in other matters as well as other similar matters, especially the UAPA matters in not just in the Supreme Court, but also
stay on with me. Siddharth Rage has some points to add. Siddharth, over to you.
In the first part that I read earlier, we've spoken about the mobilization that happened, right? Now we're going to talk about what the Solicitor General talks about is the second phase of the conspiracy. So point number 147, what we are seeing on the screens, this says that the second phase of the alleged conspiracy is stated to have commenced on 2nd January 2020, when Sharjil Imam allegedly posted content on his Facebook page advocating a chakka jam. On 9th January, which is about 7 days later, he is alleged to have conspired with Afreen Fatima to organize a meeting at JNU on 10th January 2020, aimed at mobilizing crowds from Jamia, JNU, Old Delhi, Seelampur to establish protest sites similar to Shaheen Bagh. So they wanted to replicate the Shaheen Bagh model in these 4 places. The stated objectives of these protest sites were allegedly to enforce chakka jams and engineer riots. On 13th January 2020, Nadeem Khan is alleged to have sent Saiful Aslam and Asif Tana to meet Sharjil Imam at Jamia Millia Islamia University. CDR analysis is stated to confirm Sharjil Imam's presence at JMI at the relevant time. It is further alleged that Sharjil Imam facilitated Nadeem Khan in raising and securing the Khureji protest site. On 16th January 2020, Sharjil Imam is alleged to have delivered another provocative speech, portions of which have been extracted in the charge sheet, wherein he purportedly referred to blocking access to the northeast and advocated organized actions through chakka jams. So this is the second part, part of the conspiracy that the Solicitor General talks about. The charge sheet further alleges that Sharjil Imam delivered similar speeches at Asonal and Chakand on 22nd January and 23rd January respectively, wherein he stated to have provoked sections of the Muslim population by inciting them to participate in disruptive chakka jams. According to the prosecution, those speeches taken cumulatively led to the establishment of the Shaheen Bagh protest site, which is alleged to be the first successful model of a chakka jam. Thereafter, several such protest sites were allegedly created in parts of northeast Delhi. In furtherance of the alleged conspiracy, riots are stated to have occurred in northeast Delhi in the last week of February 2020. The charge sheet thus attributes responsibility to Sharjil Imams, Umar Khalid and their associates for the protests and consequential riots that occurred on 23rd, 24th and 25th February, resulting in the loss of life and damage to public property. So this is a detailed part of the second part of the conspiracy that has been mentioned in this charge sheet, that specifically talks about Sharjil Imam's role in not just mobilizing but then in turn also activating these chakka jams in several parts of Delhi.
All right. Sambhav does want to add more to this. Sambhav, please go ahead.
Important points, yes. A 430 point where the Supreme Court is saying the accused in respect to whom the bail is declined. Here the Supreme Court in 430 point said that this court is satisfied with the prosecution material, taking at face value as required at this stage, discloses a prima facie attribution of a central and formative role. Central and formative role, these are the words used by the Supreme Court in point number 430, where the accused in respect to whom the bail is declined. The Supreme Court has said that discloses a prima facie attribution of a central and formative role by the appellants in appeal arising from this particular SLP, that is the Umar Khalid and Sharjil Imam, in the alleged conspiracy. The material suggests involvement at the level of planning. This is what the Supreme Court now is saying at 430 point, that the material suggests involvement at the level of planning, mobilization, strategic direction, extending beyond episodic or localized act. The statutory threshold under Section 43, Clause B, Subclause 5 of the Unlawful Activities Prevention Act 1967, that is the UAPA Act, Section 43, therefore stands attached with these applicants, that is Umar Khalid and Sharjil Imam. While the period of incarceration undergone by these applicants, this is what point number 431 is saying, while the period of incarceration undergone by these applicants is substantial and has been duly considered. Now, the court is not persuaded that The court is not persuaded that on the present record, continued detention has crossed the threshold of constitutional impermissibility so as to override the statutory embargo. And also another very important point, 432. See, these points are important, 430, 431 and 432 of this particular judgment, where accused in respect of whom the bail is declined. Here the Supreme Court is saying, we reiterate that courts are under a constitutional obligation to ensure that criminal proceedings, particularly those involving prolonged pre-trial incarceration, should progress with utmost expedition. Now the Supreme Court is in a way answering to those who question this particular case as the trial is delayed. Here the Supreme Court is saying that the courts under constitutional obligation to ensure that criminal proceedings, particularly those involving prolonged pre-trial incarceration, should progress with utmost expedition. So here Supreme Court is saying that this should progress with utmost, expedition, and the accused are not left to languish in jail. Here another important point, and at the same time, the court is mindful. This is, I'm reading it further, the point number 432 of this judgment, which is at 136, page number 136. Here the Supreme Court is saying that the court is mindful that pre-trial detention, even when justified by statute, cannot be permitted to continue without regard to the progress of the trial, and the restraint on liberty contemplated by law must progress alongside a meaningful advancement of prosecution. In the present case, now the Supreme Court is referring to this particular
case. All right, Sambal, stay on with me. Siddharth Rege will add a few points.
Vaishali, we've spoken about the role of Sharjeel Imam. Now let's focus on the role of Umar Khalid, as has been mentioned in this particular judgment. This is obviously the charges that have been leveled. Now this point, which is point number 211, states, the prosecution narrative as pleaded is not episodic, it is architectural. It asserts a phased progression, mobilization and indoctrination, institutionalization through committees and digital platforms, expansion of protest sites into permanent blockades, preparation for escalation, culmination in coordinated chakka jams and widespread violence. The role attributed to Umar Khalid is not of a late entrant nor of a peripheral sympathizer. It is of an organizer. So very important words being used here against Umar Khalid. They are clearly establishing and accusing him of being the organizer and coordinator who, according to the prosecution, supplied the method, the timing and the linkage between dispersed sites and actors. The factual record placed by the prosecution repeatedly returns to a distinction that is central to the case, the differentiation between a conventional dharna and a chakka jam. This is not treated as semantics, it is treated as strategy. A dharna may be expensive, a chakka jam, as alleged, is disruptive by design. The prosecution case is that the sustained choke-in of arterial roads, replication of blockade sites and the movement of crowds from minority clusters into mixed population areas were not accidental expressions of dissent, but calibrated acts meant to generate confrontation, overwhelm law enforcement and create conditions for violence. It is in this backdrop that the material regarding 13 December 2019 Jamia is relied upon. So very specific charges being made against Umar Khalid. And I'm going to further take you through what else has been said. Having regard to the prosecution material as placed, including the chronology of meetings, the alleged articulation and propagation of the Chakka Jam strategy, the operation of coordinating committees and groups, the protected witness statements alleging preparatory and escalation-related discussions, the pleaded movement of protest activity into mixed population zones, and the alleged systemic disruption of civil life in the national capital, this court is satisfied that reasonable grounds exist for believing that the accusations against Umar Khalid are prima facie true. So big statements being made by the court there. I'm going to read this point again for the benefit of our viewers. Having regard to the prosecution material as placed, including the chronology of meetings, the alleged articulation and propagation of the Chakka Jam strategy, the operation of coordinating committees and groups, the protected witness statements alleging preparatory and escalation-related discussions, the pleaded movement of protest activity into mixed population zones, and the alleged systemic disruption of civil life in the national capital, this court is satisfied that reasonable grounds exist for believing that accusations against Umar Khalid are true. This is the part that is important. This is the part that needs to reach Zoran Mamdani as well and other people who, or just on the basis of rhetoric and narrative, form opinions and they try to influence opinions. But this is what is the most important part of the judgment copy.
All right, Sambhav, would you like to add something to that?
Well, absolutely. Here, Siddharth is breaking down the important points of the judgment, and here I just want to add on few more points. The point number 436, concluding observations by the Supreme Court. Before we conclude, the Supreme Court says in point number 436 of its judgment, before we conclude, it bears a reiteration that a principle lies at the heart of constitutional adjudication in the matters of this nature. The Constitution, now the Supreme Court is talking about the Constitution, Indian Constitution. The Constitution guarantees personal liberty, but it does not conceive liberty as an isolated and absolute entitlement. Now, this is very important here. Again, the Supreme Court is talking about constitutional liberty. On one hand, the liberty given by Indian Constitution, especially Article 21 of Indian Constitution. Supreme Court here in its judgment, and I quote, the Constitution guarantees personal liberty, but it does not conceive liberty as isolated or absolute entitlement, detached from the security of the society in which it operates. The sovereignty, integrity, and security of the nation, as well as the preservation of the public order, are not abstract concerns. Rather, they are constitutional values which Parliament is entitled to protect through the law. So the right to liberty is not absolute in nature, is what is said by the Supreme Court. And in the judgment further reads, where a special statutory framework has been entraced to address offences perceived to strike at these fundamentals, these foundations, courts are duty bound to give effect to that framework, subject always to constitutional discipline. So here the Supreme Court is not just talking about the constitutional rights, but also the constitutional discipline which is to be adhered to, especially when it comes to maintaining the public order, security of the nation. And remember, these are the concluding observations made by the Supreme Court two-judge bench after signing off at page number 142, where Justice Arvind Kumar and Justice N.V. Anjaria penned these particular judgment penned by judges. And these are the concluding argument. These are the concluding remarks in the judgment. And also, just one important point I want to add on, and point number 437. In the application of such law, the court does not proceed on identity, ideology, belief, or association. It proceeds on role, material, and the statutory threshold governing the exercise of the jurisdiction. The criminal law does not mandate identical outcomes merely because of the allegations arise from the same transaction. So, those alleged to have conceived, directed, or steered unlawful activity or terrorist activity, the word used is unlawful activity or terrorist activity, stand on different legal footing. Now, the very important point, those alleged to have conceived, directed, or steered unlawful activity or the terrorist activity stand on different legal footing, is what is said by Supreme Court in pointer number 437. Very clearly said. On point number 436, the Supreme Court is talking about constitutional discipline. And in point number 437, the Supreme Court has said that the court does not proceed on identity, but proceed on role, material, and also the most important point, those alleged to have conceived, directed, or steered unlawful activity or terrorist act stand on different legal footing from those who allegedly involved, whose alleged involvement is confined to facilitation and participation at a different level. So here, Supreme Court in a way is differentiating among accused on these basis and clarifying as to why Supreme Court on one hand has granted bail to 5 accused and denied bail to these
All right,
two
Samar,
accused.
thanks for joining me. And with that, we're slipping into a short commercial break.